This diagram compares the US federal system with the UK's Unitary framework. On the left, federal power is permanently divided between national and state governments. On the right, the UK unitary state is a single, solid block of authority. Westminster owns all legislative power, merely lending out sections of it to the devolved nations, sections it can legally erase at any time. This brings us to the bedrock rule of the UK Constitution. The UK Parliament retains absolute, overriding legal authority to pass legislation for England, Wales, Scotland, and Northern Ireland. Now, Westminster has delegated day-to-day legislative tasks to devolved institutions in Edinburgh, Cardiff, and Belfast. But because the UK is unitary, Parliament legally retains the power to override their laws, or even abolish those devolved institutions entirely. If you apply American federal logic to UK constitutional exams, you will fail. A UK Act of Parliament that directly overrides a devolved Scottish or Welsh law is fully constitutional and legally binding. This chart details the reserved powers model. Scotland and Wales can pass laws on almost anything, unless explicitly listed as reserved matters, like defense. Courts apply a purpose test to check a law's aim. Furthermore, devolved legislatures cannot violate protected human rights statutes. When assessing legislative competence, the courts look at the primary aim of the law. If a Scottish bill has an incidental effect on a reserved matter, it survives, provided its true purpose targets a devolved issue. Looking at this chart, Northern Ireland uses a distinct three-tier model: transferred, accepted, and reserved matters. Crucially, unlike Scotland or Wales, the Northern Ireland Assembly can legislate on a reserved matter, but only if they secure explicit consent from the UK Secretary of State. Watch out for this exact trap on your exam. A reserved matter means strictly hands-off in Scotland and Wales. In Northern Ireland, it simply means requires permission. Politically, Westminster tries to avoid stepping on toes. Under the Sewell Convention, the UK Parliament promises it will not normally legislate on devolved matters without asking the relevant devolved legislature for permission, using a legislative consent motion. But the Supreme Court clarified the legal reality in the Miller case. The Sewell Convention is a political courtesy, not a legal rule. The courts cannot invalidate a UK act simply because it was passed without devolved consent. Let's test this with a real scenario. Does the Scottish government have the legislative competence to pass a bill for a purely advisory independence referendum without UK consent? This Supreme Court judgment gives us the answer: no. Even an advisory vote has a consequential connection to the reserved matter of the Union of Scotland and England. A political workaround making the vote non-binding fails against the strict legal boundaries of reserved powers. This diagram illustrates the two emergency brakes the UK government can pull to block devolved legislation. The process splits into a judicial challenge and a political veto. Down the judicial route, UK law officers have the authority to intercept a devolved bill and refer it directly to the Supreme Court for a ruling on its competence, completely pausing the process before it ever receives royal assent. This flowchart highlights the second path, the political route under Section 35 of the Scotland Act. Crucially, a Section 35 order allows the UK Secretary of State to veto a bill, even if it falls perfectly within the legislature's competence. This veto is triggered if the UK government argues the devolved bill alters how the law applies to reserved matters, creating adverse effects across the rest of the UK. Having legislative competence does not guarantee a bill will become law. The UK Internal Market Act 2020 prevents trade barriers via mutual recognition and non-discrimination. Products meeting English standards automatically clear regulatory borders into Scotland or Wales. The only exception? Devolved nations bypass these rules by negotiating agreed exclusions through UK-wide common frameworks. To master devolution for the SQE, keep the hierarchy clear. The UK Parliament remains absolute. The language of competence demands precision, especially the definition of reserved in Northern Ireland. Ultimately, Westminster holds both the legal and political leash on the devolution framework.